Hello everyone, I am going to discuss with the topic that is rule of transfer of title on sale. So this is the rule which is based on the maxim called Nemo Det Quod Non Habet. So everyone is aware about this Nemo Det Quod Non Habet. But what is the provision says under the Sale of Goods Act 1930? So we have to study under section 27. So this is a very important and very interesting topic under the Sale of Goods Act for the CA Foundation's business law students as well as the Ll.B students. So let's start with the topic that is rule of transfer of title on sale. Now what is this rule says? So the general rule relating to the transfer of title on sale is that the seller cannot transfer to the buyer of goods a better title than the himself has. So the general rule it says that the seller cannot transfer a good title to the buyer because he does not have it. He himself doesn't have, then how he can transfer his title to the buyer? So if the seller of the goods, the title is defective one, the buyer's title will also be the subject to the same object. So if the seller's title is a defective one, then buyer is also going to be the defective title. So because he does not have what he does not have, how he can transfer? So this is the rule will apply. So this is your general rule says. But what the provisions of the Sale of Goods Act that section 27 says, we have to study now. So section 27 has laid down that where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had. This rule is expressed by the maxim Nemo Det Quod Non Habet, which means that no one can give what he has not got. So section 27 of the Sale of Goods Act says that where goods are sold by a person who is not the owner of the goods, first thing. Second, who does not have the authority from the principle of the owner of the goods to sell the goods. Or third things, he does not have a consent of the owner, then how he can give a better title to the buyer of the goods, because the seller itself is not having that. So this rule is called as a Nemo Det Quod Non Habet. The exact meaning of this Latin word is no one can give what he has not got. So if you do not have this, and how you can give it to others? So what is the motive or the intention or the object behind the general rule is what we have to see. So the general rule aims at protecting the interest of true owner and is deemed necessary in the larger interest of the society. So the intention or the motive of the or aims of the general rule is that protect the true owner, the real owner or the original owner, and it is necessary to protect the larger interest of the society. So that is why if a thief disposes of stolen property, the buyer acquires no title though he may have purchased the goods bona fide for value, and the real owner of the goods is entitled to recover possession of goods without paying anything to the buyer. So the thief, suppose he has a stolen property, because he wanted to dispose the stolen property, then the buyer, he has purchased from the seller and he has purchased in good faith, that is for bona fide he has purchased, and for value he has paid the consideration also. But the real owner is the owner who is going to or entitled to recover the possession of goods and without paying anything to the buyer. Because it is a stolen property, thief has stolen the property and he has sold it to the buyer, then he does not have the ownership on that and title to the property, then how he can give it to the others? So that is why who will be the true owner, he is going to get it, or he is entitled to the possession of the goods as well as the ownership. So, and he don't have to pay anything to the buyer also. This is the law or the rule is protecting. This is very, very important rule has provided. Thus, after going to the principle or the maxim, so we can analyze that. Thus, a buyer cannot get a good title to the goods because or unless he purchases the goods from a person who is the owner of the goods thereof and who sells the goods under the authority or with the consent of the owner. So buyer cannot get a better title because he is not purchasing the goods from a person who is the owner of it and who does not have the authority to sell the goods from the principal or any or the owner of the goods. Or third thing, he does not have the consent of the owner to sell the goods. Then how the buyer will get a better title? He cannot. So as we know, when there is a law, there is an exceptions, because we cannot sustain with the the rigid law, the strictness of the law. So there must be somehow some flexibility has to be provided. Then and then the society can very flexibility can run. Now the exceptions we are going to study. So the transfer of title by non-owner. Even if he is not an owner, he can transfer it. Now, what is the exception? The first exception is an unauthorized sale by a mercantile agent. The two words is important under this first exception: unauthorized and a mercantile agent. Two things we have to describe here. We have to analyze. Section 27 says, a mercantile agent meaning is given under this 27, an agent having in the ordinary course of business as such agent authority. So the mercantile agent is an agent who has in the ordinary course of business. That means he should have a business and he can have an authority. He can either to sell goods or to consign goods for the purpose of sale, or to buy goods, or to raise money on the security of the goods. This is the meaning of the mercantile agent. He can sell the goods. He can also entrust the goods for sale to somebody else, or also he can buy goods also, and he can also raise money. That means he can take a loan by giving a security of the goods for a loan. So this is called a mercantile agent. So thus, as a rule, a mercantile agent having an authority to sell goods conveys a good title to the buyer. So he has an authority, he can sell the goods and he can also transfer good title to the buyer. He can transfer the good title to the buyer. This is his authority as per the mercantile agent, and this is provided under section 27. Now in the later part of the mercantile agent, I have to explain the point that is unauthorized, how unauthorized and how we can make it authorized. So we will explain that. But by virtue of these provisions, because of these provisions, a mercantile agent can convey a good title to the buyer, even though he sells goods without having any authority from the principal to do so, provided the following conditions are satisfied. So this provision says mercantile agent can convey. That means we have seen he cannot do it because he does not have an authority, right? But we said yes, he can do it. That is an exception again. He can do it, but without having authority from the principal also, he can sell the goods. He can transfer the title to the goods when he has to satisfy the conditions. What condition he has to satisfy? The first one is he should be in possession of the goods. He must have the possession of the goods and documents of title to the goods in his capacity as mercantile agent and with the consent of the owner. So one thing is that he must be having a possession of the goods, and secondly, ownership, that is a document of title to goods. That means ownership lies with him, and that is he is having it as a capacity of mercantile agent. He must having some signature on it that principal has authorized him as a mercantile agent. So this is required, and he must have a consent of the owner. Owner consent is required. If these things are satisfied, then he can very well sell the goods without having any authority from the principal also, because every moment and every time and here and there he cannot take the permission from the or authority from the principal to come with it for the selling of the goods. So second condition he also has to comply with, that is he should sell the goods while acting in the ordinary course of business. He should sell the goods. He should sell the goods, but he must act it in the ordinary course of business. He must be dealing with the business. He must be acting as ordinary business. He must act it. Third condition he has to satisfy, that is the buyer should act in good faith without having any notice at the time of the contract that the agent has no authority to sell. It is a little critical here, it says. So buyer has to act in good faith. He should have a faith on it. He should have a trust on it. Buyer should trust on him. With whom? That is a mercantile agent. Without having any notice. And the buyer should not have any notice. Notice, that is an informations. He must not have knowledge. He must not aware at the time of the contract, when the contract is going on with him and the mercantile agent. He must not have this. And when that is what notice he should not have, that agent has no authority to sell. He should not aware or should not have any information that the mercantile agent doesn't have an authority to sell the goods. These things should not be at his knowledge at the time of the making of the contract. If these three conditions are satisfied, the mercantile agent can still sell the goods to a buyer, and he can convey the transfer the title to the buyer. Now, to make it more clear, we are putting one illustration over here. It's a very famous case, Fox versus King. In this case, F has entrusted his car to a mercantile agent for sale at a stated price and not below that. The agent sold it to B. Right? A mercantile agent has sold it to B, a bona fide purchaser. So below the reserve price and misappropriated the proceeds. So B resold the car to K, the defendant. It was held in this case that B obtained a good title to the car from the mercantile agent, and he conveyed a good title to K, and therefore F was not entitled to recover the car from K. Now I will explain this. What wanted to say here, for F, he has given his car to sell the car to a mercantile agent, and he also said that I have fixed up the price, you have to sold the car by this amount only, not below that. Right? It is mentioned. But mercantile agent sold it to B. He sold it to him. A bona fide purchaser means he is a genuine purchaser without any notice he is having, and below the reserve price. And the stated price was there, but he has sold it just lesser to the amount which is stated, and misappropriated the proceeds. That is why it is a amount as a misappropriation made in that particular proceedings. So B has also resold the car to K because the agent has sold it to B, and he is a bona fide owner. That is, he got the title, he got the ownership, documents of title with him. So he has resold the car to K, the defendant. Then, because in this case, that is why decision given is that it is right that B can obtain a good title to the car from mercantile agent, and he conveys a good title to K, and therefore F was not able to recover the car from K. Now here B got the title, good title or ownership over the car from the mercantile agent, and that's why he is entitled to sell the car to the K, and K will get a good title because B was having, and therefore F cannot get back or recover the car from K. He cannot ask from K because both are bona fide purchaser, and they get a better title, good title, documents of title to goods they are having. So this is it's clear in that, because though you are not having an authority, you can do it, but this is the three conditions you have to perform, you have to satisfy. Now it is clear on that point. Okay, because unless and until you have the ownership or title to the goods, you cannot give it to anybody else. The second exception is transfer of title by estoppel, section 27. It's a very, very important principle, that is estoppel. Must know the meaning of the estoppel. Lord Halsbury has stated that. So estoppel arises when you are precluded from denying the truth of anything, when you have represented as a bona fide, as a fact, although it is not a fact. So estoppel will arise when you are precluded, you are stopped from denying the truth of anything. You are stopped to deny the truth of anything, because you have already stated the truth to a person. That is, you have represented as a fact. You said this is the fact and this is the true fact. So believing on that, somebody has already believed it. So it is, although it is not a fact, but you have makes other person to be believing it as a fact, and it is a truth you have said. That is why how you can later on deny it. You cannot deny it. That is called estoppel. It is stopping you from denying. So this is Lord Halsbury says about it. So thus estoppel means that a person who by his conduct or words leads another to believe that certain state of affairs existed would be stopped from denying later on such a state of affairs. So estoppel means the person who by his conduct or words, because you have made such a statement by your conduct, by your words, you make another person such a situation, such a position that to believe that so certain state of things or state of affairs existed. So it is, you have stated in such a way that these are the a statement you made in such a way that you said it is stated and it is existed, the state of affairs exist. So that is why another person will believing it. So then you will be stopped, then you will be stopped from denying later on that such a state of affairs does not exist. Later on you cannot say that no, this is not the true things, I have mistakenly I have given the statement which is not actually truth. You cannot later on deny that. So this is what the estoppel plays a very good role. So estoppel is stopping anybody to the unfair or unadvantage, undue advantage. You cannot take it. So that is why later on you cannot state that you are not saying the things. Now the basis of the estoppel is that. So what estoppel based on what? It would be bona fide, it would be unfair. It will be unfair or unjust to allow a party to depart from a particular state of affairs which he has permitted another person to believe to be true. So the basis of the estoppel is that. So your estoppel is just protecting you. So it would be unfair. Estoppel says it will be unfair. It will be unjust. That means undue advantage you are going to take. It will be it is not advantageous. So it is unjust to allow a party to depart from a particular state of affairs. You cannot stopping anybody from that. No, you don't go for this state of affairs. I have mistakenly stated you is a true facts. So which has permitted another person to believe to be true. Because on the basis of your statement or the expressions, he has believed it and acted upon it. So you are stopped from denying later on. So this is the basis of the estoppel played a very good role. Now to clearing this point, we are putting in one illustrations over here. We will see the illustrations. The facts is that I am the owner of a wagon allowed one of his employees, K, to have his name painted on it. I did so for the purpose of inducing the public to believe that the wagon belongs to K. C purchased the wagon from K in good faith. C acquires a good title as M is stopped from denying K's authority to sell. So M, who is that? He is a owner of a wagon. He allowed one of his employee, name is K. So he told K, as an employee, to have his name to be painted in such a way in the wagon that it should believe that it belongs to him. So M was having a purpose. He purposely did it to make the name of the stated in the wagon in such a way. It was his purpose of that inducing the public to come and believe it that wagon belongs to K. So he has insisting him to do this because he wanted the public to believe that this belongs to K. So see, on the basis of this, belief, the faith, the C has purchased a wagon from K in good faith. So in faith, he has bona fidely, C has purchased the wagon from K. So that is why C acquires a good title. So that's why if the C thinking that it belongs to K, so K can give a better title to C. and M is stopped from denying K's authority to sail. So later on, M cannot say that no, I have not given authority to sail the walk unto sea. He cannot say that. He's stopped from denying. This law has stopping him from denying that. So this is called rule of estoppel, how it applies in particular facts of the cases. So now clear on this point? So this is estoppel is a very important principle to be known, and I think so you are clear today the concept of estoppel also. So by this way I will complete my sessions for today, and this another next rest of the exceptions. So we are altogether 8 exceptions are there. So the rest of the exceptions I will be giving you. I'll be coming with the next video, and that is the exceptions to the rest of the points I'm going to discuss. So till then, keep watching my videos, and this is a very important and a very vital the topic from the set of good sex, and everyone should know and go through the sections. 27 is a very important sections from the point of view of your examinations, and I am sure that you will not going to lose any questions, anything, any corner of the portion they will ask you. You can damn sure you can write a very good attempt, you can make it. So till then, keep watching. Please subscribe to my channel, and please share it and like it. So